here the Supreme Court in its decision, I think, really went out over its skis in knocking this out, because it not only disrupted the U.S. economy in terms of pulling the rug out from under the president and a key funding, a key way of funding the government, but it's going to disrupt our foreign relations. And I don't think our system's set up to allow the courts to do that. So much happening, including the late-breaking news of a important and historic and unfortunate, in my view, Supreme Court decision eviscerating the president's ability to issue tariffs under an important law authorizing, seemingly, as President Trump has alleged, the emergency use of tariffs authorized by Congress. And that was the debate before the Supreme Court, because businesses and others sued the Trump administration, alleging that the tariffs that he's been imposing as he tries to wield the power of the presidency to protect the economy, as he has asserted, to address national emergencies, and use the tariffs to get foreign governments to do what he wants them to do. Kind of just proving the point that it's a careful, and however you may disagree with tariffs individually because of matter of policy, but it's a tool of trade in terms of foreign policy. And unfortunately, the Supreme Court ruled in such a way as to undermine the president's ability to use the tool of tariffs to address national emergencies in the foreign policy sphere. And so that's the essence of the ruling today. But of course, I say it's the essence of the ruling. Others will say, Tom, look, there was a lot in that decision. And indeed, here is the decision. I may hurt my back lifting it up. 170 pages of decision by the various justices of the Supreme Court. And so the argument is about a law called what is the law called? The International, of course, everyone pretends they know what it is because, they're talking about it repeatedly today, but probably no one knew about it till Trump started using it. The 1977 International Emergency Economic Powers Act. And as Justice Kavanaugh wrote in his decision, the president has imposed tariffs on imports of foreign goods from various countries under this law. And it's generated all sorts of policy debates. But the policy aside, the question is it legal or appropriate for him to do so? And I think the president has the more persuasive case. Now, the majority of the justices, by a vote of 6-3, found he could not exercise the tariff functions he was exercising under this law. He could do all sorts of other things, but not tariffs, which doesn't make any sense, as I'll go to in a minute. Yes, the law at issue is the ability to, quote, regulate importation under the 1977 International Emergency Economic Powers Act, or the EPA law, as it's known by its acronym. So the big debate is, does regulate importation mean you can issue tariffs? And the justice's decision, as I noted in my response to it initially, is confused. Now, 6 justices said no, but they disagreed as to the reason. So you have 3 justices saying, look, the plain reading of the statute says, and these are the liberal justices, there is no authority to issue tariffs. It lists what the president's able to do, and you can't, under the plain reading of the statute, say that regulate importation includes issuing tariffs. 3 other justices, led by Chief Justice Roberts and Justice Gorsuch agreed with him, and Justice Amy Coney Barrett agreed with him, said, look, the major questions doctrine, right, which is conservatives have applauded in terms of the justices' decisions recently in that regard. You can't, hide an elephant in a mouse hole, right? That the president doesn't have authority to impose tariffs forever and a day anytime he thinks there's a national emergency in a law that's written the way it is. It's at odds with history, and it's just too much. And if the Congress wanted specific authorization for this really enormous tariff authority, the justices, then they should have put it in there. And there's a question of whether they could have put it in there and delegated their authority completely, and there's a dispute even about that. So you've got 3 justices who say he can't issue tariffs because he's taking too much power under the reading of the statute. So let's say in theory he could issue a tariff under the language, but that's just too much power, and it's a major question, and Congress has got to be more explicit if it's going to grant him that. You've got 3 justices who say he can't issue tariffs because, why? Because the statute doesn't allow him to, just outright. You don't have to get into the issue of whether it's a major question or not. Because the left doesn't like the major question statute because they want presidents to be able to do anything, whether or not it's authorized by statute, like forgive student loans as Biden tried to do, et cetera. So it's a kind of an interesting issue because they've ruled that he can't issue tariffs, but they don't agree as to why. And if a lower court or other courts are looking at it, there's no majority opinion. It's 3-3-3. Now the 3 other justices, Justices Kavanaugh, Justice Thomas, and Justice Alito, disagree that the major questions doctrine applies. I mean, this is, it doesn't apply in cases related to foreign policy. And it doesn't make sense to read the law the way it's being read. So I would encourage you to review the opinion yourself if you want to go through the 170 pages. But I'll draw your attention to an interesting part of the opinion, at least as it relates to Justice Kavanaugh's dissent, because to me, I think personally he has the better of the argument. And I think and Justice Thomas and Justice Alito, who I admire beyond measure. So as Justice Kavanaugh starts off in his dissent, I've got it here, acting pursuant to his statutory authority to regulate importation under the 1977 International Emergency Economic Powers Act, the President has imposed tariffs on imports of foreign goods from various countries. The tariffs have generated vigorous policy debates. Those policy debates are not for the federal judiciary to resolve. Rather, the judiciary's more limited role is to neutrally interpret and apply the law. The sole legal question here is whether, under IEEPA, tariffs are means to, quote, regulate importation, unquote. Statutory text, history, and precedent demonstrate that the answer is clearly yes. Like quotas and embargoes, a quota is you can only import, or if you're a country, send over to the United States a limited number of goods in a particular category, and embargoes, which in theory can completely prevent trade. So the president could say no goods from Iran are coming in, for example. So like quotas and embargoes, tariffs are a traditional and common tool to regulate importation. I think that's a powerful argument, and it gets even more powerful once you kind of see how the logic is being ignored, frankly, by the majority, in my view. Since early in U.S. history, Congress has regularly authorized the president to impose tariffs on imports of foreign goods. Presidents have often used that authority to obtain leverage with foreign nations, as we've seen President Trump was doing up until, frankly, today. Help American manufacturers and workers compete on a more level playing field and generate revenue for the United States. The plaintiffs argue, and the court concludes, that the president lacks authority under IEEPA to impose tariffs. I disagree. In accord with Judge Taranto's careful and persuasive opinion in the Federal Circuit, the Federal Circuit is a branch of the lower courts that considered this case. They ruled against Trump. Judge Taranto dissented. I would conclude that the president's power under IEEPA to regulate importation encompasses tariffs. As a matter of ordinary meaning, including dictionary definitions and historical usage, the broad power to regulate importation includes the traditional and common means to do so. In particular, quotas, embargoes, and tariffs. History and precedent confirm that conclusion. In 1971, President Nixon imposed 10% tariffs on almost all foreign imports. He levied the tariffs under IEEPA's predecessor statute, the Trading with the Enemy Act, which similarly authorized the president to regulate importation. Those tariffs were upheld in court. So he kind of goes forward and describes, Justice Kavanaugh does, that this is not a controversial issue for Congress to authorize the president to use tariffs as a cudgel, right, as a stick, and a carrot, obviously. Importantly, IEEPA's authorization for the president to impose tariffs did not grant the president any new substantive power. Since the founding, numerous statutes have authorized and still do authorize the president to impose tariffs and other foreign import restrictions. IEEPA merely allows the president to impose tariffs somewhat more efficiently to deal with foreign threats during national emergencies. Context and common sense buttress the interpretation of IEEPA. The plaintiffs in the court acknowledge that IEEPA authorizes the president to impose quotas or embargoes on foreign imports, meaning that a president could completely block some or all imports. But they say that IEEPA does not authorize the president to employ the lesser power of tariffs, which simply condition imports on payment. As they interpret the statute, the president could, for example, block all imports from China, but cannot order even a $1 tariff on goods imported from China. That approach does not make much sense. Now, there you have it. I don't understand why any justice of the Supreme Court would rule that you can shut down, literally shut down trade from an entire country, but the lesser measure of tariffs to regulate trade or importation is not available under the statute. It's simply not persuasive to me. It's not persuasive. Now, to be fair to the other side, they're concerned tariffs or taxes. The Congress is, under our Constitution, supposed to be the one raising and setting tax rates, not the president. And they just don't see them being able to either give away this power, or if they're not explicit about giving it away, allowing the president just to interpret the statute to use the power as broadly as President Trump has sought to use it. But in my view, President Trump has used it as the law allows, and as Congress should have reasonably foreseen, as a tool for foreign policy. And President Trump's whole philosophy and way of approaching the issue of tariffs has been, there's this awesome power we have that we're not using to benefit our country, and you could list all the reasons and back and forth as to why, and I'm going to use it the best I'm able to do under law. And that's what he sought to do. And I think in kind of, this is my summary of what I think went on with the kind of how this case shook out, especially among the difference between the conservatives who voted against Trump and the conservatives who supported his decision or his application or interpretation of the law, is that I think they didn't like the policy. If President Trump, I suspect, and I'm just speculating here, but you know, take it for what it's worth. If President Trump, for instance, had said, look, there's an emergency with fentanyl at Mexico's border, and I'm imposing tariffs and duties until the Mexicans clean up whatever they need to clean up in a way that I find sufficient. There's a national emergency. Tens of thousands of Americans are dying. It's largely coming through the Mexican corridor. They're not doing enough to secure the border, and you know, and that was the limit of it. I suspect forgive me for ascribing improper motives to the justices, and I'm not. I just suspect If he was more limited in the application of tariffs under the statute, the justices, or many of them, wouldn't have had the problem they have with it. They just don't like him doing it broadly, and in my view, as a result, they said you can't do it at all. So in essence, to me, it's a policy dispute. That's how I read it. This is a political decision, and I think I'm fairly analyzing it. But in the end, I'm frustrated because, as I said, it is a tool for foreign policy, and it's one less tool. Is it the end of the world? No. But it's, I think, a poorly reasoned decision. When you have, on an important matter like this, the majority unable to come to a conclusion as to why they are ruling the way they are, in a way that anyone can point to and say, well, that's the position of the court. We don't know what the position of the court is. You got 3 justices who say it's for one reason, and 3 justices who say it's for another reason. Is it unprecedented? No. Sometimes the courts split up like that. But they split up on this core issue of presidential power. And the president's ability to use a tool. I mean, just think of our relations with Great Britain or Europe. If we want Europe to do something we want them to do, what other tool does the president have other than tariffs? I'm exaggerating for effect, but you get my point. They're not our enemies. They're our trading partners. And that's our economic relationship is core, it could be argued, to how we interact with them. And the president, in exercising foreign policy, doesn't have access to the ability to deal with, to manipulate and set tariff policies, despite Congress saying in national emergencies, you bet he does? I don't buy it. I just don't buy the majority analysis there. You know, and to be clear, there's an argument. You know, and I'm not saying they're completely wrong, but I'm just saying it's more political. I suspect it's more reaction to his broad assertion of the power than the power itself. If he had done it in a more limited way, I don't think he probably would have had the problem with the court he has had. But as Justice Kavanaugh later points out, well, let me just read what he says. So this is another part of the decision that's important in terms of policy. Although I firmly disagree with the court's holding today, the decision might not substantially constrain a president's ability to order tariffs going forward. That is because numerous other federal statutes authorize the president to impose tariffs and might justify most, if not all, of the tariffs at issue in this case, albeit perhaps with a few additional procedural steps that IEPA, as an emergency statute, does not require. And then they list the statutes: the Trade Expansion Act of 1962, the Trade Act of 74, the Tariff Act of 1930. I mean, you've all heard of Section 301 fights, right? You know, all of those types of battles to impose tariffs. In essence, the court today, this is the key part, concludes the president checked the wrong statutory box by relying on IEPA rather than another statute to impose these tariffs. So in the meantime, and as he goes on to say, this is going to be a substantial issue. There are hundreds of billions of dollars, almost $200 billion in tariffs that have been collected. Does everyone get them back? How? What's the damage if you are able to incur, for instance, let's say I had to raise my prices by $1 to cover the tariff costs. You got the dollar back from the increased price. So what is it you get back from the government? Are you harmed? Is there money that you should get back if the cost of the tariffs were covered by your price increase? It's a complicated question. It's not like someone can go and ask quickly for their money back, because there has to be, it seems, a more careful analysis, because it's taxpayer money that's going to be going out the door here if everyone who got tariffed gets their money back. And then secondly, and arguably more important because of the foreign policy concerns and the implications of this decision, we've had foreign policy trade agreements, some of which are substantial, that relied on and were made in as a result of the president's authority he was exercising under this law. Do all of those go up in smoke? So here the Supreme Court in its decision, I think, really went out over its skis in knocking this out, because it not only disrupted the U.S. economy in terms of pulling the rug out from under the president and a key funding, a key way of funding the government, but it's going to disrupt our foreign relations. And I don't think our system's set up to allow the courts to do that. You know, and it occurs to me, I'm not a lawyer, but I know a little bit about the way the Supreme Court thinks on some of these constitutional issues, and courts think. They got this way of talking. It's just like, you know, if we can figure out a way to resolve a case and avoid a constitutional battle, we're going to. And I tell you, I would have figured out a way to resolve this so it didn't result in disruptions to the world economy, because, especially since the justices can't figure out why exactly Trump violated the law. Doesn't that suggest maybe there's no there? Now, I know the constitutional lawyers, and I can kind of envision the arguments they're going to be making, but, you know, I think I kind of take a practical approach to these decisions. I mean, they're obviously legal decisions. They're opinions of the Supreme Court of the United States, but the court does what it wants to do, and that's the way our system largely allows it to do. And we're allowed to look at the material and figure out whether it makes rational sense. And I don't think it does. I don't want to overstate it, because as Justice Kavanaugh says, maybe there's less here that meets the eye in terms of the impact on the presidency. But it was an emergency statute, and the president didn't have to go through. So these other tariff laws that Justice Kavanaugh references require administrative action before they're imposed, studies and such. And it's a Megillah to try to get those imposed, because people challenge the studies, and, you know, it just leads to litigation and such. So it's certainly going to put a pause on the tariff regime that the president has imposed. He can't just start it up immediately. There's going to be a lag time, and it could be significant. So an interesting case before the Supreme Court. It's an historic case. This is the type of case, however unfortunate in my view, that we'll be talking about, or our descendants will be talking about in 60, 70 years. It's that important a case as it relates to presidential power. And that's why it's so unfortunate that it's confused, illogical, and probably will have to be fixed later by future courts. So there you have it, my take on the biggest case of the Supreme Court session, I would suspect, other than the one coming up for Judicial Watch with our election integrity case. We're asking the Supreme Court to uphold a victory that finds the counting of late ballots that arrive by mail to be illegal. That decision will come by the end of the term. Our argument is next month on that. But this is a pretty darn big decision. There are other big ones coming too. But I wanted to give you some feel about how to think about this. And if you're feeling skeptical about the logic behind it, you're right to do so. And I don't know if you saw President Trump's press conference on it, but he was largely right on his analysis of the case. And I'm glad he's reading it and explaining it to the American people too. I thought that was a very good moment in terms of educating people about what the court did right and wrong, in terms of the dissent, in my view, got it right, and the majority got it wrong. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.